Hello, this is Dale Wetzel. We're coming to you. This is the Legislature Today radio program. We're coming to you from the Peacock Alley American Bar and Grill in downtown Bismarck, and it's light outside still. I'm still getting used to that, the changeover to daylight saving time. This evening, in the first hour of our show, we're going to be talking to the chairman of the House Judiciary Committee. His name is Kim Koppelman. He's a state representative from West Fargo. He's a Republican. We're going to be speaking to him in the first half hour about new legislation to improve or to toughen up penalties against drunken driving, and also some constitutional amendments that are in the House Judiciary Committee, of which he is the chairman. In the second half hour, we're going to be speaking about a proposal in the North Dakota Senate to eliminate the possibility that locked-out workers may collect unemployment benefits. This has been an issue with the American Crystal Sugar Company lockout. The Supreme Court ruled last month that those workers can indeed collect unemployment benefits, and the North Dakota Senate has a provision in a Job Service North Dakota bill that would make sure that that does not happen in the future, that workers get unemployment benefits if they're locked out of their jobs. That led to a bit of a debate in the North Dakota Senate today. We'll be speaking about that in the second half hour of the show. In the meantime, these are some of the other things that went on in the legislature today. The Senate defeated one of several constitutional amendments that would abolish the Board of Higher Education. The Board of Higher Education is kind of a target during this session, partly because the board has gotten some criticism for the performance of its newly hired chancellor. One of the amendment that was defeated was sponsored by Park River Republican Senator Joe Miller. It would have replaced the Board of Higher Education with a Council of Regents, which would have been made up of the governor, the Department of Public Instruction superintendent, and the Agriculture Commissioner. Those would have been the voting members of this Board of Regents. There would have been 8 other Board of Regents members, 6 of them appointed by the House and Senate majority leaders and 2 appointed by the governor, but they would have been non-voting members. That proposal was defeated 34-13. There are a couple of other proposals to get rid of the board and replace the board with a kind of a mega higher education administrator who would have charge of the presidents of the North Dakota University system and the system in general. One of them calls for electing the higher education commissioner. The other one says that the governor should appoint the director of higher education as part of the establishment of a new department of higher education. Those will come up in the House later. The one that was defeated that I mentioned that would have established a Council of Regents was a Senate constitutional amendment that was defeated today. As far as hearings, there was a hearing about a bill to require personal finance instruction in the 7th and 8th grades. This would include instruction on how you balance a checkbook, how you save for buying a car or another large purchase, how you use credit, how you figure interest rates, the role of taxes in your employment, how you make a budget, your rights as a consumer. There is instruction on these subjects in high school, but this would provide some additional instruction in the 7th and 8th grades, or 7th or 8th grades. This bill is sponsored by Minot Representative Roscoe Striley. He is a Republican from Minot. There is also a bill to increase the penalties for using a fake ID to buy alcohol. Right now, that is a Class B misdemeanor on the first offense. A Class B misdemeanor carries a potential jail term of 30 days, a fine of $1,000. This bill would impose minimum sentences for a violation of this nature. If you did it for the first time, if you either used a fake ID to buy alcohol if you're underage, or if you are of age and used your status as a legal liquor-buying adult to supply someone else who was underage, you would get a minimum $500 fine and 40 hours community service on your first offense. In the second offense, you'd get a minimum $1,000 fine and 80 hours of community service. And on the third offense, if you know, on the theory that you're really haven't learned your lesson on this one, the third offense would carry a Class C felony penalty, which is 5 years in the state Gray Bar Hotel and a $5,000 fine. Again, this would apply for both using a false ID to purchase alcohol and for purchasing alcohol for someone who is underage. There was a rather unusual study resolution that the House approved today. It has to do with the study of whether it's advisable to use different types of tobacco products as an alternative to smoking cigarettes. This is a study resolution that's pushed by the tobacco industry. They have a gentleman by the name of Brad Roku who promotes this. He is on the medical school faculty at the University of Louisville. He was here to testify on that bill, and he acknowledges that his work is financed by the tobacco industry, but he says it is nonetheless factual that using smokeless tobacco, using other tobacco-type products that deliver nicotine is less dangerous than smoking cigarettes, and that if someone insists on smoking cigarettes and nicotine gum doesn't do it for them, or they can't quit, that it's better to switch them to something that's a little less harmful than smoking cigarettes. And the resolution that the legislature dealt with today was about whether the legislature itself should study this topic over the next 2 years. And it received a almost unanimous recommendation from the House Human Services Committee that this proposal should not be approved. In other words, they were not interested in having this subject studied, and it would be, frankly, an unusual subject for the legislature to study over 2 years. But this resolution was approved 48 to 46. That's as close as it gets in the North Dakota House, because the House has 94 members and you need 48 votes to get anything approved. So we will see how that flies in the North Dakota Senate. The Senate will be looking at this study resolution. And how this works, frankly, is that there are a number of requests for study resolutions that are approved in the legislature. And at the end of the session, shortly after the end, these are all stacked up, examined, and then the legislature makes choices on which subjects to study. And most of the subjects that have study resolutions are, in fact, not studied. They are put aside, and other subjects that are considered to be of higher priority are studied. Well, we'd like to turn now to our guest this evening. One of our guests, his name again is Representative Tim Koppelman. He is a Republican from West Fargo. He is the chairman of the House Judiciary Committee. Welcome, Mr. Koppelman.
Well, thank you, Dale. It's good to be back with you again.
Thank you, sir. And we're going to be talking at first about a proposed, there are essentially two bills in the legislature right now that would increase the penalties for drunken driving. One of them was approved by the Senate, and it's in the House right now. The other one was approved by the House, and it's in the Senate. We're going to be talking primarily about the House bill, and it had a very auspicious beginning. There was a news conference in West Fargo to announce its introduction. This is before the legislature began, and it was inspired, if that's the term, by a horrific crash that last July that killed a West Fargo family, and then the crash was caused by a drunken driver who was driving the wrong way on Interstate 94. And so this family was from West Fargo. They lived in Representative Koppelman's district, and he is the chairman of House Judiciary, and he's taken the lead on this particular bill. And Representative Koppelman, could you tell us what the bill does now and a little bit of how it started?
Sure, I'd be happy to, Dale. The bill, it's House Bill 1302, if anyone is interested in that information, to track it in the legislative process. And it began, first of all, let me back up to the beginning, because I am not normally in favor of a fan of what I call knee-jerk legislation, which is we see quite often, frankly, and you've been around the legislative process, that you've seen it, you know what I'm talking about, where there's some kind of a tragedy or some kind of a problem, and people rush out and say there ought to be a law and introduce a bill and so on. And the reason I say that is that oftentimes those things are well-meaning, but they are too often feel-good legislation that really doesn't have a meaningful effect and so on. So when I approached this issue, I tried to do it rationally. In fact, the media first contacted me when the accident you referred to occurred, and my first reaction was, we have made the drunk driving laws tougher in North Dakota since I've been in the legislature, and we may need to look at doing that again. But a law alone, a change in the law alone, will not solve this problem. It needs to be a cultural change, and I still firmly believe that. I was criticized by some people for that, saying I was soft on drunk driving and all the rest. That's not true. But I do believe that no matter what law we pass, unless we as North Dakotans all play a part in this process and just change our culture, which currently says, drinking and driving is okay. Getting drunk and driving is okay. Because a drunk driving offense now, a DUI, is usually met with either a wink and a nod or a sigh of relief. I'm glad it wasn't me that got caught. And then we are horrified when a drunk driver kills or maims people. And what I've been saying the whole time is that those dots don't connect. So what I did is I started talking with the law enforcement community, with the governor's office, with the attorney general's office, with people that, and when I say the governor's office, the highway patrol, people like that,
yes,
that deal with this every day. The governor's attorney is a former state's attorney. He's prosecuted DUI offenses, dealt with a lot of these different folks. I spoke with state's attorneys, I spoke with judges, and said, how do we really get on the same page here and find a meaningful piece of legislation that we think will make a difference and will work and will be part of starting this statewide conversation we need to have about making drunk driving laws tougher. That was the genesis of House Bill 1302, and initially the bill was a bit tougher than it is now. In fact, it was amended twice in the House, once by our Judiciary Committee and then later by the Appropriations Committee.
And why did the Appropriations Committee change it?
Well, that's a good question. They would tell you it's because of the dollars, and certainly there are dollars involved. If you incarcerate more people, it costs money. If you have more people in the system in one way or the other, it costs more money. If you prosecute more people, it costs more money. So that's just part of the reality of life. But that's what government's for. So one of the purposes of government. So I don't necessarily balk at that. I'm not a big spendthrift. I'm a fiscal conservative, but I do believe that government needs to do what it needs to do. But some would argue that what the Appropriations Committee did was perhaps dabbled in policy a little more than it should. I've been on the Appropriations Committee. I served there for 4 years. I've been on policy committees all the rest of my legislative tenure. So I've walked in both sets of shoes, and I understand both roles, and I respect both. But I believe that, that's not the argument for today. In fact, when that bill hit the House floor after the Appropriations Committee made their amendments, I still advocated for the bill. I advocated for its passage. I spoke to it considerably on the House floor as the carrier out of the Judiciary Committee, and we were pleased to see it passed. The way the bill was originally introduced, and I should point out first of all that none of these things change the actual criminal penalty. It's still a Class B misdemeanor for a first-time DUI offense under any versions of House Bill 1302. The changes that we made were that we discovered that even though a Class B misdemeanor means conceivably a first-time offender could go to jail for up to 30 days, virtually no one ever goes to jail at all for a first-time offense. It's just become a kind of a cookie-cutter approach to how we deal with these issues. And the law enforcement people, the prosecutors and others said, that's our problem. People need to see a little time in the inside of a jail cell as a wake-up call to say this is serious. So all of the versions of the bill have some jail time. The original bill had 4 days of mandatory minimum jail sentence on a first offense. The House amended that, leaving the 4 days, but changing it from a .08 blood alcohol level, which is the threshold for being stopped for drunk driving, up to a .15, which is almost double that level, and kept the 4 days. The Appropriations Committee moved that up to a .21, which frankly I think is too high, but that's where it is now. The process isn't over till it's over. And they reduced the 4 days to 1 day at that point, and it has to be a day when the individual arrested is not scheduled to work. So that's where the bill stands now. That's how it was sent over to the Senate. There's a hearing tomorrow in the Senate Transportation Committee that I'll be attending and introducing the bill and asking that the committee support it, and I'm certainly open to other amendments and other ideas. And then we progressively get tougher in these bills on fines as well, and also on repeat offenders. The thing that a lot of people on the House floor commented to me about after the vote on the bill, after the House passed it, is they said, I had no idea that first offenders were such a threat. And I have to say, I felt the same way. When I looked at this issue, I had kind of a preconceived idea that, the real problems when it comes to drunk driving are the people who are repeat offenders, who have had many DUIs, who are maybe have revoked driver or suspended licenses and all that sort of thing. I discovered that in 2011, which was the last year for which there are statistics on this, or the most recent year, I should say, out of the 55 alcohol-related fatalities on our highways in North Dakota, 42 involved first-time DUI offenders. And that tells me that there's a real problem with first-time offenders, and if we don't get this problem nipped in the bud initially, we're not going to deal with it comprehensively.
I think that one of the, you mentioned that your initial impression was is that the big problem were repeat offenders and people who get really drunk and then go out, and that was frankly reinforced by the West Fargo case, because this gentleman had several DUIs. He had driver's license suspensions. He was well above the legal limit, and he was driving the wrong way on the interstate highway, which tells you something. And people think, well, he was smashed out of his gourd, and those people are the problem. But it was a quite fascinating statistic that you brought up on the House floor, that if you have 55 deaths and 42 of them are caused by first-time offenders, then obviously first-time offenders are your biggest problem.
That's right. And we do want to get tough on those repeat offenders. And one of the things we're doing that I think is creative in the bill, the Attorney General has done a lot of work on this, is the 24/7 program, which means that those on a suspended sentence, if after they serve whatever it becomes, a day, 4 days, whatever it ends up being, if they're during that 30-day sentence, the rest of that suspended sentence, they would have to come in twice a day and test and not be drinking, not have any blood alcohol level. And some people have said, well, heavens, it's drinking is not illegal. It's illegal to drink and drive, so why do you tell them they can't drink? I said, well, this is a suspended jail sentence. If you weren't suspended, you'd be in jail. You can't drink in jail either. So it's part of their punishment. And it's a good way, and some have talked about ignition interlocks. I think one of the other bills talks about that. Current law allows that, so this wouldn't change that. But ignition interlocks are the devices that you blow into, and you have to blow without any blood and alcohol in order for your vehicle to start. And that's fine, except as it's been said in North Dakota, with many of us owning several cars, with people borrowing other cars and all that sort of thing, ignition interlocks keep the car from driving drunk. 24/7 keeps the driver from driving drunk.
What, if you could change the House bill as it is unilaterally, what would you do?
Well, I think this is, as you know, Dale, it's been said many times that politics is the art of the possible. And so what I want is a tough bill that can pass. I mean, we can create a much tougher bill and beat our chests and say, look at us, aren't we great, we're tough. And if the bill fails, we've really accomplished nothing. But if we can find a bill that strikes the balance between winning the support of those who may think it's a little too weak and winning the support of those who may even think it's a little too strong in order to get it passed, that's really the magic formula. If I had to guess today, and I don't have a crystal ball, but I think something in the neighborhood of what the House Judiciary Committee amended it to, maybe a 0.15, 0.16, 0.18, something like that, which is double the legal limit. You're pretty intoxicated when you're at that level. That should, in my mind, have some mandatory jail time. It shouldn't rise to 0.21 to do that. And whether it's a day or 2 or 4, I don't think 1 day is enough. Is 4 too much? You can have that debate.
Well, one of the primary objections that were raised during the debate, as you know, were that, first of all, the 0.21 for a mandatory jail sentence. I mean, you do not, if you get into a car and drive and you're 0.21, you know that you're drunk. I mean, it's not as if you've, I had 2 beers and I got behind the wheel. Well, I'm sorry, but that doesn't happen when you're 0.21.
Exactly.
And the other thing that I heard objections to were the 1 day in jail and the fact that it can be a non-working day when the person's not scheduled to work.
Yes.
Because the whole point of this is to have some inconvenience, frankly, to the driver.
Exactly. Well, and you make good points, and those are precisely the reasons why I think the way the bill left the House is a bit too weak. On the other hand, it's stronger than what we have now, so that tells you something.
As the chairman of the Judiciary Committee, you're handling a number of constitutional amendments, and I was wondering.
Before we shift gears, please, may I just answer just a couple more things?
Not at all.
One is, and I think you make really good points when you talk about the perpetrator of the accident with the West Fargo family. There was another horrific accident where a drunk driver left the road, ran over a tent, killed some young boys of a young family, and they've been at the legislature this session as well, the Ruiz family. But it occurred to me when I thought about the facts of that tragic West Fargo case, exactly what I've been saying. No law would have stopped that incident, I'm afraid, because as you say, he was a repeat offender. I don't even know if he had a suspended license or was legal to drive. I think the only thing that would have stopped that event that night would have been one of about three things. One would have been a bartender saying, "You've had too much to drink, I'm not going to serve you anymore." Two might have been someone in the bar saying, "Friend, I'm taking your keys. You're not going to drive. I mean, I'll call somebody to give you a ride. If it's in an urban area, I'll call a cab, or I'll give you a ride home myself," whatever it would be, but I'm not going to allow you to drive. Or number three, if none of those worked, calling the police or the sheriff or the highway patrol and saying there's someone getting behind the wheel of a car that should not be. That would have saved some lives. But that's not our culture in North Dakota right now. And that's why I think this bill, whatever it is when it passes, and I hope it does pass, that it's just a wake-up call. It's a piece of the puzzle. It says we're serious in North Dakota, and it begins to change our culture.
Well, we have that bill that Representative Koppelman just described. Well, there's also a Senate bill, a bill that was came out of the Senate, and it's would require a mandatory jail sentence or community service at the level of 0.18% blood alcohol level. If you did not have that severe of a problem, your fine would be doubled to $500 if you are below 0.18 and above 0.08, which is the legal limit presently. We're pretty much we're close to being out of time.
No, I'm sorry,
not a problem. We're close to being out of time, and how do you see this playing out? We've got about 30 seconds left, actually.
Sure. Well, the Senate hearing is tomorrow, and I look forward to the testimony. I believe some of the families that you've mentioned will be there and tell their story. The Senate has heard some of this already with the other bill, as you talked about. Obviously, I don't think we'll pass two pieces of legislation. I think it'll be one. Which one, I don't know. I obviously hope it's mine. We've done some work on that, and the governor is supporting it. The Attorney General is supporting it. There have been a lot of folks involved in it that have some skin in the game, so to speak, some involvement in the issue. So, but I'm glad that there are other efforts to do something, and I hope we leave the legislative session with some good, meaningful legislation.
Thank you, Representative Koppelman. You've been listening to Representative Kim Koppelman. He's the chairman of the House Judiciary Committee. Coming up next, we're going to have some folks talking about legislation that was approved in the North Dakota Senate today that would ban payments to unemployed workers who are locked out of their jobs. And we will have Senator Tim Mathern, Senator Jerry Klein, and Senator Jessica Unruh to talk about this issue. And we will see you in a little bit. Good evening. This is Dale Wetzel. We are here this evening talking about the American Crystal Sugar Company lockout and legislation that the Senate debated today, the North Dakota Senate, that will affect whether future lockout incidents whether the workers who are locked out in the future will be able to collect unemployment benefits. We have with us Fargo Senator Tim Mathern. He is a Democrat, and he spoke on the floor today in favor of keeping things as they are now, and what as they are now is North Dakota workers who are locked out of their jobs, according to the North Dakota Supreme Court, according to current law, are entitled to unemployment benefits. And we also have with us Senator Jerry Klein. He's a Republican from Fessenden, who is the chairman of the Senate Industry, Business, and Labor Committee. We also have Senator Jessica Unruh, who is a Republican from Beulah. She was appointed to the Senate after the former District 33 Senator Randy Chrisman was elected to the State Public Service Commission, and she is serving in her first session. Welcome, everyone. First of all, Senator Klein, could you just explain to us how this amendment came to be that would prevent folks in the future who are locked out of their jobs from getting unemployment?
Well, Dale, it started a month or so ago when we had Senate Bill 2224, which was a bill which Senator Murphy introduced. And his idea was certainly to provide locked out workers unemployment compensation. It was the belief that that under current law that unemployed workers who were locked out were not entitled to unemployment compensation. That bill came through our committee with a do not pass, and it was certainly intended to move forward, intending that the current law that we believe in the state of North Dakota was that locked out workers, because it's somewhat of a labor dispute. We're not entitled to unemployment compensation. Then we had the Supreme Court decision. And that Supreme Court decision was not very unanimous, as you probably have read. It's
3-2.
3-2.
Yes.
And in it, Judge Van der Waal said, we don't know. We don't have clarity here. We need clarity. The legislature would need to address this. In his dissent, he said that. So, the Senate Bill 2224 was defeated unanimously, by the way, in the Senate. And I chatted with my colleagues and Senator Murphy, in fact, that this is an issue that we're going to have to address because we're going to need to provide clarity. And that clarity turned into the amendment to 1112. And that's what we have. And luckily enough, as chairman, I was able to have one of my freshmen, and I said, Senator Unruh, this one is yours, and you're going to be carrying this to the floor. So she's the messenger on this, and we as a committee, once again, voted party line, 5-2, that we as a state will continue to believe that locked-out workers are not compensable under our unemployment rules.
I probably should interject something. Senator Klein referred a couple of times to Senator Murphy. That's Senator Phil Murphy. He represents District 20, which includes Trail County and parts of neighboring counties in east central North Dakota. The Hillsboro American Crystal Sugar Company sugar beet processing plant is in his district. He has been a vocal advocate of providing unemployment benefits for the locked-out workers. And we asked him if he would want to come on the show this evening, and he was not able to. That's why he's not here. Senator Unruh, when Senator Klein said to you, this is your issue, how did you respond to that?
Well, he is the chair for our committee.
You say thanks a lot?
And I did say thank you. And one thing that we have on the Senate side is we do have half the people that we have on the House side. So we don't have the luxury of passing on things that we maybe would like to pass on. We have to make sure that the work gets done. And so when Chairman Klein told me that this was something I was going to be taking up, I took it and I ran with it. And I think it was really important for us to provide the clarity that the courts were looking for. They basically asked us for it. They wanted us to provide this to them. And so I did. I worked on the amendments to try and convey what the history of the legislature had shown us is to uphold those right-to-work philosophies that we've relied on in the past and just to remain neutral in labor disputes. So that's what the amendments were for, to reflect that intent of the legislature.
Do you think, frankly, that this is going to hurt you when you go up for election because, District 33 has a fairly significant labor union presence, and they probably are not going to like you doing this?
That's a really great question. We do have a heavy labor union presence within our district. We also have a lot of businesses that do not have labor unions present working for them. I have received some feedback from both sides of the issue, as I'm sure you can imagine. But I have received a lot of support from union members within our district. My husband, my brother, both members of the union, they both support the issue and the determination. We weren't, at this point, we weren't debating the issue anymore. We were just providing the clarity that the courts were seeking.
And could you just, as I understand it, this does not affect the American Crystal Sugar case, is
That's
that correct?
This is not this does not apply retroactively to any case. The American Crystal Sugar workers will receive the benefits that were awarded to them by the North Dakota Supreme Court, and this will only apply to cases going forward. And I might mention as well that there have only been 2 cases of a lockout within the state of North Dakota in recent history. So I believe the last one before this American Crystal Sugar Workers one was back in the 19th that this might happen. But we did want to provide the clarity and define what a labor dispute is in the code.
Senator Mathern, one of the assertions that was made on the Senate floor was that the North Dakota legislature needs to be neutral in labor disputes, and this is a reason for passing this bill. First, refusing to pay unemployment benefits to workers who are locked out, who are willing to work and are locked out of their jobs, do you think that that represents neutrality in state policy? And also, do you think that neutrality in a situation like this is even possible? Either you pick one side or the other.
Well, Dale, first of all, I don't agree that this was to clarify the intent. The intent of the legislature was clear. I've been in the legislature a long time. The intent of the legislature is to provide unemployment benefits to people that are not able to work, because they've been laid off by their workers or locked out, whatever the reason. If they can't work, they need some way to support their families until they find other work. I looked at the research when the lockout happened and went back, and it was my belief, and that's why I encouraged the workers to take it to court. It was my belief that the intent of the legislature was, in fact, to provide unemployment benefits. I spoke with the CEO of American Crystal, Berg, about that very issue. I went to meet with him, and I believe the court actually held out that my position was correct. The intent of the legislature was to to provide benefits. Now, the justice did say he would like clarity. Well, that's a system of voting. It's just like if I went up there tomorrow and I said to Senator Klein and Senator Unruh, my gosh, not everybody was on the same bill today. We should vote that amendment over. Well, the amendment passed by a majority. It's the same thing. The Supreme Court passed and said the benefits were available.
At least 3 of the justices thought it was clear enough to vote on.
Right. And then the other thing, I believe that this does not keep us neutral. In fact, this interjects the legislature now into labor disputes dramatically. A labor dispute, whether it's resolved in terms of a lockout or laying off workers or people working without a contract, that's continuing. But right now, this gives the benefit of the negotiation to the employer, in that a lockout then prevents workers, even those workers who are not members of the union, even those workers who would vote against the lockout, would be prevented from having benefits. And I think this is just interjecting ourselves into that environment. I think when workers are not able to work because of a lockout, and they have paid in, essentially these unemployment benefits accrue because there is a pay-in mechanism in all the years of employment to accrue a benefit, and these benefits are now denied. So I'm hoping tomorrow Senator Klein, Senator Unruh will think about this again, vote against the bill. We can get this right back to where we started.
We'll just start because I would argue that even Job Service North Dakota did believe that locked out workers were not entitled to unemployment benefits. We wouldn't have waited this long. We would have paid them immediately. They would have paid them in the last lockout issue. We have not. They felt, and some court rulings have also seemed to imply to them that locked out workers were not, and that's why that's why they have held off at this time. You think most unemployed workers aren't going to wait 2 years before they get their compensation, which is the case because North Dakota Job Service believed that they were interpreting the law the way the legislature had intended. So that could be an argument as to how you look at the intent of the legislature.
And to be fair, a district judge went along with Job Service North Dakota too.
That's correct.
That was what the decision was appealed. The district judge said Job Service North Dakota is correct, and the majority of the Supreme Court said Job Service North Dakota is wrong. Senator Mathern, could you explain the difference between a lockout and a strike?
A strike basically is where the workers themselves decide to walk out, where the workers decide in a labor dispute to leave the work site and not provide their labor to the employer. And a lockout is a situation where the employer literally locks the gate, locks the place, and says people cannot come to work. And they generally lock out everybody members of the union or non-members. And in this particular case, for example, the workers were in fact willing to continue working without a contract. And the employer...
And they'd done that in the past, too,
right,
hadn't they?
And Crystal Sugar decided that they weren't going to do that. They literally locked them out and said they cannot come to work. Even if they wanted to come to work, even if they were a non-union member, they were told they can't come to work. So it's a dramatic difference. If these employees had an option, but they didn't, they were just told they can't come to work.
Senator Klein, do you think that there is a distinction to be drawn here because the workers I know that this law doesn't affect the Crystal case, and I think we made that clear earlier, but do you think that the law should draw a distinction when it comes to unemployment benefits between whether a worker is locked out of the job, meaning that they would like to come to work but they can't, or when a worker decides they're not coming to work because they don't like their contract or they have some grievance and they're not going to show up?
Well, I think in this case, both are a result of a labor dispute, because certainly the American Crystal workers, which we always go back to because that's really been the point of this whole legislation, were offered a very great contract, a contract that even the National Labor Relations Board suggested was a pretty good contract. They opt not to take it, because of the business that American Crystal is in. Because when they begin their business, they have to continue. Once those sugar beets get rolling, they can't stop till they're done. They had to make a business decision that they were going to lock out those folks, train new ones, because they had to be ready. In the case that those folks wouldn't accept the contract, they had to be ready for the beet lift. And that's so. No one likes to see a dispute amongst whether it's an employer or employees. Everybody, I just want to get along. And, I'm sure the American Crystal workers wanted to get along, and I'm sure the corporation wanted to continue with the people they had. But sometimes, through those negotiations, issues come up that need to be addressed and aren't. And if there's an issue with, my understanding, some of those seniority issues, where we keep moving people up because they're a senior member but not as capable of running a piece of equipment as they should be, we need to address that. The employer maybe needed to address that. I don't know. But it's unfortunate this happened. It's unfortunate we're in this position. I guess I'm glad now that we realize the issue that we have with the law. Those workers are going to be compensated under unemployment. But prospectively, we know what the law is now. And we've got clarity.
Well, I've known what the law is for the last 27 years I've been in the Senate. And the bottom line is the law's been changed. If this amendment gets changed or stays in effect and this law passes tomorrow, what we have done with this, if this passes, Senator Klein, we have put every worker in North Dakota in jeopardy. And I think this is not the public policy that we ought to have in our state. This has thrown the worker into an untenable position. These are workers that have families, they have groceries to buy, they have health insurance needs, they have rent to pay, mortgage payments to make. And these workers, if we talk about American Crystal workers, they were willing to work at a lower rate than what was offered. They were willing to work at the old contract. There was a dispute about what should the new contract should be, but they didn't say, we're going to leave here, we don't get the new contract. They said, we'll work under the old contract and let's continue working. And that's the difficulty here.
Yeah, Senator, just to add a little bit here, Senator Klein, you mentioned the contract offer that the American Crystal Sugar workers had, and the NLRB's judgment that it was a decent contract. Wouldn't this logic, the logic of the lockout and being denied unemployment benefits, this would also apply if American Crystal offered them a lousy contract, said, okay, you're going to take a pay cut, or you're going to take a substantial pay cut, and if you don't take it, we're going to lock you out. Those workers also would not be eligible for unemployment.
Well, you certainly if you look at it that way, that isn't logically, because generally,
well, I mean,
employers will look at providing a nice contract. They provided a great contract. They didn't provide a lousy contract. You wouldn't have the National Labor Relations Board saying, well, thanks for offering them a lousy contract. You guys take it or leave it. I think negotiations had reached the point where they brought those folks in, and that was the sort of what you might say the arbitrator who said, hey, you know what, this deal should be working out. Those folks, say what you want. They had those jobs were good jobs in the Valley, and provided those families with a good source of income. And unfortunately, because of this labor issue, this labor dispute, was unemployment compensation going to pay for all those groceries? No, you're going to get 26 weeks of 2/3 of the average weekly wage. That's not what they want. They want a contract. They want to keep working. And I believe if we're going to look at it that way, I think American Crystal wanted them to work too.
Senator Unruh, do you believe that there is a distinction to be made here between, whether a striking worker or whether a locked-out worker should get unemployment benefits?
I don't believe that there is a difference. Both are considered labor disputes with the amendments that we passed today, and any type of labor dispute should be treated equally. And I would also like to go back to something that Senator Mathern had stated earlier about knowing what the intent of the law was through his years with the legislature, which I completely respect, but Job Service obviously didn't agree with that interpretation, and the courts in their decision, each of the judges, I think, could have agreed that the law was ambiguous the way that it was written. It was not clear to them even exactly how this should be interpreted. I know that it came out in a 3-2, but they all could admit that it was ambiguously written.
Senator Klein and Senator Unruh, I'd like to ask you, do you think that this law will result in more lockouts?
No.
Why
don't.
Not?
I think this amendment will only suggest in the law what we believed was the law. Everybody thought that lockouts were included. This doesn't change anything. Now we can see that it does. I personally don't believe this is going to change anything or create any more lockouts than we've ever had.
I'll have to agree with Senator Klein. Throughout the United States, there are it's very split on how states handle this type of situation, and I think that this was the intent of the North Dakota legislature throughout all of these years, and that goes along with many other states in the union.
Senator Mathern, do you think that this is going to result in more lockouts?
Well, I think if a corporation now is faced with a opportunity to not have to pay unemployment benefits out of their account. You see, these accounts are kept separately. This really doesn't just spread to everybody. There are accounts based on the employer, and the employer then would be financially ahead now to lock out the workers, because that clarifies that there are no unemployment benefits. And I just think that's wrong. I think that this is interjecting the legislative process into what has worked all of these years, and I believe that the fact that the lockouts haven't happened related also to the fact that employers thought they could still be required to pay unemployment benefits out of their account, and I think now we've changed that situation if this bill passes tomorrow. And I think we ought to vote against it.
Senator Klein, perhaps you can answer this question for me. If American Crystal had, rather than locking out its workers, had just laid them all off and hired new people, if they'd been able to do that, it wouldn't have had to pay the laid-off workers unemployment.
If they would have laid them off, yes, they would have had to pay them unemployment. That would, because that was no labor dispute. They would have laid them off because of lack of work or some reason related to their business.
And if they'd fired them all, because you can do that in North Dakota on most cases, And they'd have to pay them.
They'd have to pay them. But actuarially, if you're going to look at what Senator Mathern has suggested, the law that I believe actuarially was calculated on the fact that lockouts are included in the law, and that when we look at it, American Crystal now is on the hook for between $2 and $4 million, and North Dakota employers are going to be on the hook for a few of those dollars because we can't get that all, squeeze that all out of American Crystal in a short period of time. That calculation would have been taken if everyone believed that locked-out workers were included.
So, in other words, if Job Service North Dakota had believed that lockouts were included in the unemployment benefit calculation, everyone's rates would be a bit higher.
Correct.
Okay. How much is this going to cost American Crystal in terms of their unemployment rate going forward?
Well, they will go to the maximum rate, and they'll have to either go to the maximum rate or they can write a check for anywhere. Calculations are anywhere from between $2 and $4 million, because we don't know exactly which workers have gotten different jobs, which workers have found other things to do. So they're going to have to come up with that money, and their rates are going to go up. And until their account is filled back up, that cream can has to be filled back up, they are going to be paying a higher rate. And they can do that by writing a check, which will bring their rate down. But right now, their rate is going to go to the maximum.
We've been speaking with Senator Jerry Klein. He's the chairman of the House Senate Industry, Business, and Labor Committee, and he's a Republican from Feston. He's the gentleman whose voice you just heard. We've also been speaking to Senator Jessica Unruh, a Republican from Beulah, who is a member of the Senate Industry, Business, and Labor Committee, and also Senator Tim Mathern, a Democrat from Fargo. We've been talking about the American Crystal